Well, Mr. Teeter, are you covering for Miss, I know there's a lot of trials today, are you covering for Miss Mollet?
I am.
Okay, so I just want to give you all time to do what you all do to see what's ready.
Okay.
I'm ready, but,
I know that, Mr. Neff might be ready to address the court on one.
okay, Mr. Neff,
Good morning.
good morning.
On Mr. Lowry, OOW.
Yes, Mr. Locke.
We had advised the court this week, we filed it, just received a couple types of discovery, and now we asking for continuance today. So, I would say to reset this for another route setting.
All right, well, let me ask the state, has, everyone shown up on this matter for?
Judge, yes, there have been, a lot of people here that have shown up on this, I think. Some are in the room on the Lowry case and some are outside.
All right.
I just let the police get.
Okay, I know there was some discussion of whether or not the victim had been notified to be here today, and whether or not the victim had show
That's correct, there was a subpoena that was issued, but it did not show. The
service.
return days of Friday or Thursday, whatever we were gonna.
I can check with the officers to see if the victim is here, Judge.
Okay, yeah, let's do that, I'm gonna give you a few minutes to do that,
Okay.
okay?
Thank you.
All right.
Okay, Mark.
Yeah, that's what I'm doing.
Okay.
Mr. Greenberg, you have Bailey. Is she here yet?
Yes,
Okay, so this IRC report, have you seen it?
I have, thank you, yes, she would ask for you to have the report. And,
Well, let's wait till Mr. Teacher gets back, and then I'll be ready. I'll be ready for that. Yeah. Try this second.
Here. Judge, I found out a little bit on the Lowry case.
All right.
Judge, Police Officer Charles Bell is here in Portland, along with a lot of other officers out in the hallway. I'd asked him whether, looks like Kristen Miles is our victim. Right. And she is not here as of right now.
I haven't seen her yet, I'm not sure.
But she was there.
Well, that's the thing, Judge, I think it's, might have gone out to her direct address, but as far as Officer Bell's concerned, there was not a subpoena issued to him, to the person that served to the victim. So I don't think the victim would be the person that served.
I see. All right. Bless you, please. All right, so, Mr. Knapp, your oral request for continuance, is objected to by the state?
It is not.
All right, so I'll grant that,
Thank you.
and let's, go ahead and get another date. Now, we've done a, final pretrial on this already, so I'm just gonna set it for trial.
That's fine, Your
Is
Honor.
that all right?
And as far as I know, all the discovery that exists, I received the end of it next week.
Okay.
I'm sure whoever is in here next, which prosecutor, or something who's at the board, can
Now, Mr. Lowry is, in the Justice Center. Do you want me to bring him down, put this on the record in front of him?
No, Your Honor, I actually discussed this with him previously at the detention center. He understands what I'm going to do. He's here in the building, I was there since I'm going to be here.
All right. Ms. Howard?
How far out are we gonna go?
Well, they're waiting time, so we're probably looking at,
The other thing is, I would ask for the court to consider bond if there's a PRC hold on Mr. Malley.
Okay. So we're looking at, probably February. February 13th.
That's fine.
All right, so the new jury trial date is February 13th, 23. Do you want a status between now and then?
Your Honor, I don't need it. If the court would like to, an update on the progress of the case, I'm happy to set one. If it turns out there's going to be a plea or anything comes up, I'll approach the court's bailiff and we can set it that way.
All right, I appreciate that. Is time waived?
Yes, Your Honor.
Yes, will you be going up to talk with them about this?
Not immediately, but yes, I will.
All right, I'm gonna give you a speedy trial waiver and you can just return that at your convenience. Soon at your convenience. Appreciate that.
I'll get it to you at the end of the time.
Thank you. So we'll continue this to February 13th, 23. Thank you.
Thanks.
Okay, to sign out on Officer Bell, as it says here. Thank you.
Thank you.
Is everybody else still here?
Mr. Greenberg, you have Miss Bailey, and you need to talk with Mr. Teeger about it. It's an ILC.
Did you watch the game?
Yes, I'm a big, it was awesome.
It was good to have the national announcers anyway.
Yes, yes. You know, I have a T. Higgins story. Everybody gets girls because he's awesome. You know that. I got T. Higgins because, see, T is
That pass, the program pass,
he's really showing
He
his
is.
stuff.
and he's rolling the stage.
Isn't he? Isn't he? Okay.
Well, I'm glad to hear Bengals continue to win.
Yes, yes. All right, so what's going on?
So, there was a time when the court was not certain that the facility would be granted in the conditions that the court could go to the Senate. He does appear to be eligible. He acknowledges that drugs and alcohol is a life. She wants to. She actually tried to reach out to several programs and they were saying she needed some kind of work. So unfortunately, she hasn't started. So he has some sort of check with you.
I'm happy to do that. Any objection?
No.
Okay, I'm gonna do that. So, you're a signer.
She is signed up. The court has her team. And Julie Rivers, I believe. It was how let's set it on the side.
All right. I'll be ready.
Thank you.
Mr. Greenberg said he gave you your number box. Good, how are you?
Good, good weekend?
The Bengals won, so yes.
Okay. It's a little thing, you know, it's true.
It's a little.
I got an answer to your question. I talked to the clerk's office. Very cold. So what happens is if the rule goes on, they have to surrender the password to the clerk's office. So the clerk's office holds them. And then, if when the bonds are released, then Judge Crawford will set the entry release those from the clerk's office.
So who you take it to the clerk's office?
We need, either you and I, we need to discuss it all. They need to go back to the attorney. And then, whoever posts it on, if they post it, has to turn it over to the clerk's office. They'll do that on Monday.
Okay.
That way, you and I are not involved at all.
That's one.
But that's what I thought, that's the problem. Think about this. Yeah, they've done it. I talked to marketing, my message stuff.
Okay.
Yeah,
I
that-
was, okay. And you would have done, yes. Thank you.
Don't Sunday.
Thank you, too.
So my day started, so I've got an 8-year-old that means that I will never, ever get to retire.
Okay, yes.
So, you know, there's 18 to 15 in that. Yeah, so the 8-year-old, this one, so he and I have a routine every morning, so I drive him off for school, and, we just go to this and this. And mom does it, and kind of throws everything else. So this morning, I'm like, and, I gotta give mom a hug. I'll put my boots on, and then I let him keep up doing it. And, you know, he did, but he did that, let you give it, okay, well, he Thursday, you know, he goes to JP too, it's really, you know, it's like, and, where's your shoes? You're wearing that. So that's how my morning has gone thus far.
Priorities of the other month.
He did.
procedure, you all ready to talk about?
Sure.
Do I need the other lawyers on this?
I don't think so.
Okay, all right. Good morning.
Okay, so I know you don't want to hear this, Judge.
Oh, no. Let me start out with that.
I know, but I start off with that. So the problem is, 2 weeks ago, you know, I was rushed to the hospital.
I didn't know.
Yeah, so like, I was very close, I was like, and you know, I'm telling my doctor, like, listen, I can't get sick. It's just me. I got things I gotta do, so I had to do ultrasounds and x-rays and all kinds of stuff. And I thought, you know, everything is okay, so I'm sitting through trial last week. I'm in pain, but it's bearable, you know. It's not anything that's debilitating, it's bearable. But then Saturday, same thing. I had to go back to the hospital. And, you know, emergency room, you know, that's extra. You know, I'm not paying for that unless I absolutely have to. And it looks like there might be have surgery. So I think, so right now, I'm adjusting on pain meds. And you know, that's not my, I don't like any kind of thing.
I'm sorry to hear this.
So, I just need to resolve this medical issue. I just want to I want to finish this trial and then resolve this medical issue. And then hopefully that I'm okay to start some of our trials in January and I'll be able to, you know, get going there.
So you don't know if these surgery?
I probably will, but that's what they're saying,
And
that,
if you do, how long do you expect it to be? 2 weeks?
yes, that would take me like get this, have surgery in the next week or so. That just takes me to the beginning of January, so I should.
I just had surgery. I wouldn't bank on that being fine in a couple of days.
Yeah.
Well, I, you know,
Just it's helping you out.
Well, you know, there's I think we're all in the same age bracket, kind of.
No, I'm in a different age bracket than all of y'all.
No, you
I'm
not.
not.
You and I are saying.
I am the senior spokesman, so.
You know, in a bracket, we're in a bracket, right? And our bodies are
right, when you,
used to
and
10 years
when
ago,
you
15 years
wake
ago.
up and there's a strange pain and you're like,
Yeah.
what's that?
Did your client know all this?
Yes, so I've been talking to him about it and I explained to him that I feel very bad.
Is this-
But then something happens that, you know, we have to stop and do the trial, you know, but this time, you know, we have to start all over again. And nobody wants to do that.
Oh, no. So, Steve, what do you propose? I mean, obviously,
I mean, Erica, I saw Erica in the hallway last week and I was worried about her because she was obviously in distress and I tried to help her out. I mean, I like Erica. I mean, I spent this weekend preparing we are ready, but I want to do, you know, what's right for her.
Yeah.
And for her health.
yeah,
So,
that goes without saying.
yeah.
But I need you to triage your cases because I need this to be a priority in January.
It absolutely
Like,
is.
I can't make this, us in January, this, you know, we're in the same predicament. And then we get bumped because you have something else. So if we can, I'm certainly, sympathetic to, I'm so sorry. I think it would be prudent to bring your client down and put this on the record, because I just want to protect. I don't want him to, I didn't know none of this, I don't want that. So, when he's on his way, we're picking another date for it to be in January. Are you gonna be here? Yeah, because I know you're winding down, aren't you? Is everybody saying that?
No, he's no more. He's just doing something different, but he's still here.
I'm trying to get rid of the last.
Oh, old stuff.
Stupid
Gotcha.
trials that are
Oh,
good.
okay. Why do people say that?
Everybody wants to say that, they want me gone.
No.
No.
Gladly.
I was
Oh,
like,
they
really?
don't want
Okay, anyway,
Are you?
okay, good. Alright.
They asked me last Thursday.
Ms.
what service
Howard,
was
would you
on.
bring down Mr. Cross? Is, okay, great. So let's, figure out, I know you guys are already backed up already in January, but this is 2020 case, so it's gonna have to be.
Jim, I know you have a lot of people here. Is it all right if I bring up people in? Because I don't want them to not, I don't want somebody to say they're on vacation.
Yes, yes, bring them on.
I'll bring that guy.
Okay.
Early to middle is better for me.
Yeah, that's not, they're not calling it, yeah.
How's the 9th or the 17th look for you?
Not the 17th. I can do either the 9th or the 23rd.
I can do the 23rd. How about the 9th, Ms. Howard?
January 9th it is.
January 9th.
Any problems with the night?
Mr. Tierney,
Yes, ma'am.
are these all the officers on this case?
Yes, that's what I'm asking. Let me get it, the ninth problem, but as far as everything else.
Okay. Can-
Sorry, y'all.
No, it's okay. Can we do, hold on a second. I do want the defendant, I know you want to release your officers, but can you release them after the defendant's here?
Sure.
I just want him to know everybody's ready because of this emergency situation. We need to continue.
Judge, I wanted to put something on the record too about, because as always in every case I have, I would like to work with Leanne. And I want to think of her head, I don't know if
Put it
the
on
board
the
feels
record.
appropriate that
That'd
I
be
could
great.
lay out, so we could either work out a plea just on this case, whatever, try to work out a number. We could try to patch it up with the one up to Judge Gary. So either way, we could try to resolve it. If he wants to plead to this, then take his chance with that, that's fine. And if you want to try to work out something on both, that would be fine too.
So,
Judge, you know, the other thing we were waiting for your ruling on the evidence ruling on the hearing that we had held last week, because I think you were gonna let us know before the trial. So we don't need to know today, but we probably need to know before the trial started.
I said you could use, I already ruled it, you use witness statement.
And I think you were about the 404B, you were, yeah,
Yes,
there's some witnesses.
yes, I was going to do the balancing. Okay. Yeah, I will let you know. the order.
Okay.
I was hoping that my waiting to, reveal my decision would lead to some discussion.
And maybe we could, yeah, maybe that one.
Can I have them stay in the hallway, guys, or something? Or do you want to sit in the room? Okay, thank you.
You want, is it okay to release Mr. Clifford with the admonishment that he needs to be here January 9th at 9 o'clock?
Yes,
That's him right there.
yes,
So he can,
yes. You can.
right, I'm gonna leave.
Okay, thank you. Mr. Bennett, time wait.
Time later.
Thank you. Okay, that's all I do. Thank you. Mr. Greenberg, I'll be ready right after we do this one.
Yeah, just leave it that way.
Just, yeah, so-
You wanna go more?
yeah, just so they can have that.
Okay. Okay. We were in a holding pattern, so, cross the center and then that gets it.
Ms. Glazer is in her session.
They say they present the grades. Mr. Fox, Ms. Paulson, right now you two are next.
Right.
And
Ms. Austin. I saw her check in a little bit, I think, Mr. Teeter's gonna stand in, or what's going on with that.
Mr. Teager, are you standing in for Ms. Paulson this morning on?
I am, Judge.
Oh, okay, well, Mr. Fox is here.
You want us to, how bad
This is a matter of State of Ohio versus Leandre Glenn. Case numbers B2103303 and B2102474. Mr. Glenn is represented by Mr. Brad Fox and Mr. Seth Teeger on behalf of Ms. Holston for the State of Ohio. Mr. Fox, Mr. Glenn is upstairs at the
Yes,
Justice
sir.
Center. Do you want him brought down?
not for reasons for this right now, Your Honor.
All right, so this matter was set for jury trial today. What's the status? Is Ms. Holston available?
Judge, she is in progress with Ms. Underwood in room 370 with Judge McBride. That is going to be finished either today, possibly tomorrow at the latest. So if we started, I don't know if they can start tomorrow or Wednesday, but I don't know if there have been any negotiations with the defense attorney to proceed on this.
We've had pleading negotiations. Mr. Wood has rejected the state's offer So we'll be prepared to go forward, whenever the court needs us to start.
Okay. Can Ms. Postal start on Wednesday? I believe something was, my memory serves me correctly. I believe she had, some conflict at some point on Wednesday.
It's my understanding from speaking with her this morning, without going into detail on record of what it was, she said that due to some other things, she does have some conflicts tomorrow and Wednesday that she has to be at because of what circumstances came about last week. So I don't know where that puts us as far as timing.
So, yeah, could you confirm with her?
Can we approach the judge?
Sure, because I want to see if we can start this maybe, well, sometime this week.
So maybe for Erica, Libby, but Lizzie was having, she thought it was chest pains last week in this trial, so they had to like break for the day.
They didn't call the school.
They called the school. It was but she didn't get taken. But she went to the doctor. She spent like 6-8 hours at the hospital, like 10 or 11 at night, and then they determined that it was probably a gallbladder.
Okay.
That so I think for right now it's okay, but according to them, they think it has to come out. And I know she's got a meeting with the surgeons either Tuesday or Wednesday, so I don't know how much.
Yeah, from what she said, she was a smaller guy for 2 So I don't know what time or how long it would take.
Well, what I want to know is if we can't start on Thursday, can we even start? I mean, she has physical condition.
Yeah, see, I think she feels okay now, but it's something that I think it could, like, where whatever position it's in, it's okay, but it could flare up and she could be like in extreme pain and need like an emergency surgery, so I'm not sure.
Or she needs to do surgery.
And he says like, yeah, because I think with this, they don't really like to schedule it too far out.
Right.
I don't think. I don't know if it has to come out, I don't know.
I have a jury in town by Thursday, to do it this year. So that's what I'm trying to figure out.
I can walk next door and,
Can you just confirm?
because I think they're working on some kind of redactions.
Angela and I are playing with ideas because we knew there were 2 sets of circumstances that could potentially welcome us or not welcome us. Being Lizzie in trial.
Yeah.
And then just underway, also in trial, but then having another trial, which I think that one just got moved.
Correct.
But,
It's a heavyweight fight where they're just knocking each other out.
Yeah.
so,
I really wanted to do either crossing or
Let me, I know they're working on redactions, I'll try to find her. and
Okay,
get an
all
answer.
right, thank you.
Okay. I just don't want to miss, I don't want to miss the deal.
Yeah, I don't-
everything else I have is in here, so
Okay.
I'll be here.
Perfect.
I'm gonna wait for Alice here.
Okay, perfect, thank you.
Sure. Judge, can you call, John Rigsby?
Sure. What's the status? We ready for trial today?
No, we're not prepared for trial for Ms. Risky this morning.
Is she here? Can you call out to the, outside, see if she's here?
Yeah, she does not appear to be here, but I have been in contact with Ms. Rigsby. She does have all of her discovery, and she may not be here because I had explained that I was in trial, I thought I also explained that she had to be present today, but, sometimes things get confusing, when you're trying to, talk to individuals. I know she recovered from, her medical, situation, so, but she does not appear to be here this morning.
Steve,
Judge, I would ask for a fake yes.
this matter has been set 1, 2, 3 times in trial. First time, June 6th, and, there was an oral motion to withdraw as counsel, so the trial date was vacated. And then, the trial was set in October 3rd, and, defense asked for a continuance because Ms. Grigsby, had a baby, by cesarean and needed to be off, and so we continued it to today, and today she's not here. So, Kate is to issue 25,000 straight. And
If I can get in touch with her and get her here, would the court consider lifting the case?
I would consider it.
Okay, because again, fairly certain I told her about today's date, but I've also told her that I had a conflict, so that may be why she didn't think that she needed to be here. So I will call her and talk to her.
All right, thank you.
Thank you.
What's this?
When I called, they said they were a little shift change, and they will bring me down.
Mr. Fox, can we talk about Mr. Fox? Yeah. Ms. Skinner? Okay.
Judge, if you ever walk up this door, and that way I would see Cross coming, I can try to find Lizzie. I'm gonna try to multitask.
Okay.
Probably not a good idea, but I'm gonna try.
Her system is.
Yeah. But she still has to work.
Like, put them together. Put them together. We continued it to the 16th.
So you vacate today?
No.
The 16th.
And that's that, January or December 16th? December, what time is your trial start?
It's supposed to start at 9, so we ran into an evidentiary issue. So we're supposed to be working on redacting, a statement, so I need to get back as.
Yeah, sorry for being late, he's supposed to be here. All right, he's on his way. Yeah.
See the jury boxes over what's going on.
Oh, here we go, there it is, all right, we're ready.
Judge, I did find Ms. Paulson, she's outside, and she's gonna come in right when we get done with this.
Thank you. This is the matter of State of Ohio versus Aries Cross. Leonard Riston and John Clifford. Case numbers B 2002020A, B, and C. Mr. Cross is present in the courtroom with his attorney, Ms. Erica Underwood. I will note for the record that Mr. Clifford and his attorney, Mr. Bennett, were present in the courtroom and have been excused. And on behalf of Mr. Riston is Ms. Hayes, and standing in for Ms. Angela Glazer. All right, this matter is set for a jury trial today, and let me ask the state, are you prepared?
Judge, we are ready to go.
All right, and Ms. Underwood, on behalf of Mr. Cross.
Your Honor, I am not here to proceed today. There are a couple of issues that I have. First of all, I am in progress in another room. We did know or expect that. Then also I've had a medical emergency that's developed recently. I have been in constant contact with Mr. Cross, so he kind of understands what's going on here. I've explained that, it's my anticipation that this will be set the first available date in January. So he understands exactly what's going on here, and we will be prepared to proceed on that day.
All right, thank you very much. Mr. Cross, I know you've had an opportunity to speak with your lawyer. Do you understand everything that's going on?
Yes.
All right, and are you in agreement for this to be continued?
Yes.
All right. And this under the wait time?
Yes.
All right. Mr. Teeter?
Judge, and we're good with that. And I don't know whether we've really had any plea negotiations or discussions. I briefly spoke to Ms. Underwood, Judge, before court about whether there was anything we could do to resolve this short of a trial. There's a few different ways to go. There is another case that's assigned to Judge Gehring. That's the attempted murder felonious assault case up there. There's the drug case and its associated counts down here. I'd be happy to try to talk to Mr. Cross from Ms. Underwood about a resolution of this just in and of itself without any connection to the other one, or if we want to try to work out a package with the other one, I would do that. If he wants to try to plead out to this case and let that case just go to trial, I'm good with that as well. It would have to involve a penitentiary number, Judge, for sure. I know it's an MDO spec now, which kind of ties the court's hands. If he's convicted, there's, I think, a double-digit number that the court has to give. In terms of plea negotiations, we would be willing to take off that MDO spec or enhancement and work out a penitentiary number short of that into the single digits on this case, if the defendant wants to do that. So kind of the ball's in his court on that now, Judge, and I don't know whether he and Ms. Underwood had a chance to talk about that or not, but we would be willing to explore that if he wants to.
All right, thank you, Ms. Underwood.
Mr. Cross has heard what the prosecuting attorney said, and I will certainly talk to him when he and I have an opportunity to speak.
All right. Well, and I understand there are a significant number of officers present for trial today. They're here in the courtroom and outside, and this is representation you're making about willingness to enter into plea negotiations with their consent.
Yes, Judge, it's all with their consent. We've had discussions about that. This is with their consent and permission, and it is a resolution that we're all trying to get. I saw Mr. Cross shaking his head as if he's not interested, but certainly I'm not going to take that as a definite no. But if he wants to talk to Ms. Underwood and approach us, I'd be willing to sit down with her and talk about it.
All right. So, for good cause shown, the oral motion to continue the trial is granted, and no objection by the state. The matter will be continued for trial January 9th, 2023 at 10 a.m. Ms. Haynes, does that date work? First of all, is there any objection, and does that date work well for Ms. Glazer?
There's no objection, and that should work.
All right, so the matter will be continued for trial January 9th, and I am going to make this a priority on January 9th. It will be first up. If there's wait time, all right, if there's nothing else, we will continue this matter to January 9th, 2023, defendant is remanded.
Thank you, Judge.
Not too bad, thank you. Did you have a good weekend?
I did.
Good.
Thank you so much.
Yes. Good game, great game.
Yes, it was. Mr. Teeter, you're going to find out about her with Ms. Holston?
Yeah, let me get Ms. Holston now.
All right, thank you. Yes, Olson's coming in. Oh, okay. And then I'm gonna do Mr. Greenberg, and I'm gonna have Ms. Miller. Have you seen the, report?
I was on my way now, thank you.
Of the city? Okay. Okay, the report. Okay, can we come talk?
Yeah. I don't have a mask, I'm gonna stay over
There's
here.
one right there.
You don't need one? No, you got one. I've been good. I don't think I've met you. Oh, Bethany Hayes. Bethany Hayes, I'm Lizzie Colston, nice to meet you.
She's in Asia.
Oh, okay.
Okay, so. And, what is now?
So I'm still in trial and error. And, I don't know if it'll be done today or not. I don't know where she's obviously done today, but, there's some evidentiary issues and we're working through those now.
Okay.
Before we put the rest of the testimony on and then closing our case. So, and I was on court, the life squad was called for because, I think everybody was outside of the attack. I wasn't. Yeah,
Thank God.
but I was in the ER all night that night and, I see a surgeon on Wednesday to see if I have a gallbladder.
Okay.
I think that until I talk to him, there is, at least I have to assume that there's significant, that I could be in that exact same situation again.
Yeah.
And I also have the doctor's appointment on Tuesday to deal with some.
Tomorrow?
Yeah,
Okay.
yeah, so,
So that is saying you may not be done other case, doctor's appointment tomorrow
right,
until Wednesday, but then your doctor appointment on Wednesday.
right.
All right. So say, let's just try to walk through the scenario. Say your doctor say, obviously you have surgery, then that takes this case off. But say they can't get you, would it be an immediate situation? You don't really know.
Well, they tried to, and
What do you mean they tried? You didn't let them?
I did not let them. They were like, what? They were like, I can tell that that you don't want to stay there. I was like, that is true. And she was like, I will let you go, but you have to call the surgeon to get in as soon as possible.
Okay, so it's an immediate situation.
So I have a feeling that he is going to want to,
It's an immediate situation. Okay. All right. Your client's in custody. I just sent
I think he's waived time all through, so.
Yeah, he has. I just set a case that is 2020, which is a Tiger's, and Tierney's case to January 9th. So this case can't go before then, because this is a 2020 case. I have to get that, it's a legal defendant case. So I would be looking at late January for this one.
Can I go with that one?
Sure.
Could you set it on the 9th, and then if that other case, I mean, 'cause that case was definitely going today, right? And it got continued. So,
Well,
could we set it on the 9th, and then if something happens?
that's
we'll-
true.
Do I will
Can this,
tell you
other
that,
victims here, other victims here.
yes,
So you can talk to them about that.
I will.
Be something record of you.
I will talk to them. I would ask that you just say on the record that you continue to the first available date, which is the 9th. There are other trials set that day, but that will be the fastest.
Yeah, okay. That's it.
What day do we get?
January 9th.
I'm fine. How's it going?
I would just set her, everyone.
Do we,
Want me to break it
if
down?
I could bring it, please just put it on the record. Does that mean the other one is up?
Yep, that means, yours was up. It's number 4. I was here on Saturday trying to figure out all the trials. Which goes first? Number 4, your but is it 15 years? Okay, because it's 10:30 already, it's all done. All right, so let's put as limited information on the record as possible. You'll talk
And
to
I
the
will,
family.
I will absolutely talk to them.
Okay, thank you.
Thank you, Judge.
To do that is, I know you have a responsibility. I know you. But guess what?
And
The beat is gonna go on if something happens to you. And so I have to take care of yourself. But it comes with those, right?
yeah, it's fine. So, well, that's why I'm hesitant to do anything before it started, before you put that started. Yeah.
All right, so there's going to, council, there's gonna be a delay, with bringing you down. So Ms. Haynes, I don't think she needs to stay, does she?
No, right.
So you can, okay, if you have something else, somewhere else to be. And then, it's gonna be delayed, you want us just to come over to get you?
As far as what happens with the record, Judge, I would think that I would ask some colleagues to cover it for me.
Okay.
I would like, and I can speak with the victim's family and, the victim's attorneys that are on the case. and explain
Okay,
that.
so why don't we just go ahead and put it on the record and then update Mr. Glenn when he comes down.
Okay.
Is that okay? Because I just wanted the original prosecutor to be here.
Thank you, Judge.
All right. This is a matter of State of Ohio versus DeAndre Glenn. Case numbers B 210-3303 and B 210-2474. Mr. Glenn is not present at this time, but is on his way down, transported from the Justice Center. He is represented by Mr. Brad Fox, Ms. Angela Glazer, but Ms. Haynes is standing in for Ms. Glazer today, and Ms. Lizzie Polson for the State of Ohio. This matter is set for a jury trial today. State, are you prepared?
Judge, I am in trial in another room at this moment. And I have expressed to the court that, I could go forward, but I have multiple medical appointments between now and when I could potentially start, that I think are absolutely necessary. So at this time, I would ask it be continued until January 9th.
Mr. Fox?
Given the situation, Your Honor, there's no objection to this, the defense of this.
All right, so for good cause shown pursuant to a sidebar conversation with the parties, the counsel, I'm going to grant the oral request by the state to continue this matter. Time is waived by the defense, and we will set this matter on January 9th, 2023. I don't foresee having another pretrial or anything like that between now and then. It's either gonna go then or not, and I hope that it is. And then we will catch up Mr. Glenn when he gets here. Ms. Polson, I know you can get another room.
Thank you.
So, all right, thank you very much.
Thank you.
All right, we're working down our list, and so this is a matter of State of Ohio versus Nathaniel Gert, case number B 220-5406.
4247. This matter is set for jury trial, and Mr. Brad Fox is present on behalf of Mr. Gurdon, and Ms. Caitlin Mollet for the state of Ohio. Mr. Gurdon is upstairs at the Justice Center for the holding area waiting to be transported to court. Do you want him here?
For purposes of what we're doing right now, I'll wait as carriage over.
All right. State, are you ready for trial?
Your Honor, the state is unable to go forward at this time. There are necessary witnesses outside the police officers that are needed to prove this case. At this time, I do not have any of those witnesses. We'd ask for one continuance and attempts to at least get one person here, so that Detective Del People said he might be able to track down the one witness, at least one witness that would help for this case. So I would ask for a continuance, but I do understand it is set for trial. People were notified and everyone's present.
Defense?
Your Honor, we're prepared to move forward today. We maintain our guilty plea, and yes, if the state's not able to move forward, the court to deny the request for continuance and grant a motion to dismiss. Obviously, if people were served, they were notified. Hearing.
Have the alleged victims been notified?
Your Honor, I'll be honest, I would have to double check the notice came back, but I did notify the victims on the address that I had located. I will note the contact we have is the victim's mother, and she was not responding to our phone calls either.
But did you have return receipt for the notification?
I don't know if there is one on CMS. We don't always get those. On this matter, I don't know if you can look it out just to verify.
I have speed witness returned and endorsed on the 23rd of November.
And I would take that as a research.
Research. All right. So we DWAT without prejudice. Mr. Greenberg. All right, this is the matter of State of Ohio versus Dion Bailey, case number B2001669. Ms. Bailey is present in the courtroom with her attorney, Mr. Matthew Greenberg, and Ms. Caitlin Mollett for the State of Ohio. This matter is set for jury trial today, but the court has received a plea forms, and the court has received a copy of the ILC report. Has the state an opportunity with the ILC report?
I don't know, but I don't know that application is accepted.
Thank you. All right. This is how your client wishes to proceed?
Yes, Your Honor, the defense will stipulate to the person in court clinic that accept this Bailey plea in this matter and to set aside the intervention with motion.
All right, Ms. Bailey, this is how you want to proceed today? All right. Are you the Dion Bailey named in this indictment? And am I pronouncing your first name right?
Dion, yes.
Dion, all right. Ma'am, how old are you?
I'm 37.
Okay. How far did you go to school?
I'm 30.
So you're able to read and write the English language well? Are you a U.S. citizen? Have you ever served in the military? Now, I'm holding up a form, a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize your attorney's signature here with his bar number. Is this your signature here where it says defendant?
Yes, ma'am.
Ma'am, this is an acknowledgement by you that you understand you have a constitutional right to have a trial, but when you sign this form, you're indicating to the court, I understand that, but I don't want to have a trial. I'm waiving my right to a trial. Is that your understanding of what you were doing when you signed this form? Did you sign this form after consulting with your attorney about your constitutional right to a trial? Do you have any questions about this form? Do you have any questions about your constitutional right to a trial? I also have a 1993-page document entitled Entry Withdrawing Plea of Not Guilty and Entry of Plea of Guilty. On the third page, there are signatures. I recognize the prosecutor's signature here, your attorney's signature here, and then here where it says signature of defendant. Is that your signature, ma'am? All right. Madam Prosecutor, would you please put the expectation of the parties regarding this plea on the record?
Yes, Your Honor, she was a plea as charged.
All right. Is that accurate?
Yes, sir.
Ma'am, are you under the influence of any medications, alcohol, or drugs today? All right. Do you now, or have you ever suffered with, or even been diagnosed with any type of mental health difficulties? All right. Are you presently under any type of probation or community control supervision in this state or any other state?
Other than you already got me in.
All right. Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today? Has anyone promised you anything at all if you enter into this plea of guilty today? Are you making this plea of your own free will? Now, the state has indicated that because we're expecting you do meet the criteria for intervention in lieu of conviction, that you will be pleading guilty as charged to count one, possession of cocaine and felony in the fifth degree. Is that what you talked with Mr. Greenberg about before this hearing? Did you have an opportunity to review and or go over this 3-page plea form with Mr. Greenberg before this morning?
Yes,
All right, do you understand what it says? Do you have any questions? Has Mr. Greenberg answered all of your questions?
Very accurate.
All right. Ma'am, do you believe you've had enough time to sufficiently consult with your attorney about your entire case before this hearing this morning?
Yes,
Has he answered all of your questions to your satisfaction?
Yes.
Have you had an opportunity to review and or discuss the evidence the state has against you with Mr. Greenberg?
Yes,
Madam Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material, if any, to the defense to your knowledge?
To my knowledge, yes.
All right. Mr. Greenberg, do you acknowledge you see the same?
We're satisfied with services.
All right. Ms. Bailey, are you satisfied with your attorney, Mr. Greenberg?
Yes,
Now, ma'am, do you understand this charge of possession of cocaine, a felony of the fifth degree that is, you're charged with? Do you understand that, if you plead guilty, you are making a complete admission that you committed the allegations contained in that count of the indictment? And, do you understand that if you plead guilty, well, if you plead guilty, the court will not enter a judgment of guilt, but I'll hold it in abeyance until you complete the term of intervention, removal, treatment plan. You understand? All right. Now, this being a felony of the fifth degree, do you understand you're facing up to 12 months in prison and up to a maximum fine of $2,500? All right. Do you understand that if I were to sentence you to prison upon your release from prison, you could be on post-release control for up to 2 years? And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand? All right. Are you on post-release control right now? All right. Well, do you understand that if you are convicted of a new felony offense and you're on post-release control, so while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, whichever is greater. You understand? All right. Also, since this is a felony of the fifth degree, community control is a possibility. You understand that? You understand that I can place you on community control for up to 5 years instead of sending you to prison? All right. Ma'am, do you have any questions at this time? When you plead guilty, you have some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to a court or to a jury of 12 persons? Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a right to have witnesses subpoenaed to come to court and testify on your behalf? Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond reasonable doubt? And finally, do you understand that at trial, you cannot be forced to testify against yourself? Do you understand each of these rights as I explained them? Do you have any questions whatsoever about your constitutional rights? Do you have any questions whatsoever about anything we discussed this morning? All right. Do you understand that if you plead guilty, you are waiving all of these important constitutional rights? All right. So knowing everything that the court has discussed with you today, you still want to enter a guilty plea to count 1, possession of cocaine and felony of the fifth degree? All right. Anything further before I conclude? All right, may I hear a statement of facts?
On or about April 2nd, 2020, in Hamilton County, state of Ohio, the defendant did knowingly obtain a Schedule II controlled substance, to it cocaine, in an amount less than 5 grams. Violation of 2925.11A of the Ohio Revised Code.
All right, Ms. Bailey, you heard the prosecutor say you did? Is it true? All right, what is your plea to count 1, possession of cocaine and felony of the fifth degree? Let the record reflect that Ms. Bailey was present in court with her attorney, Mr. Greenberg, and that Ms. Bailey was informed of all of her constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Ms. Bailey understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be voluntary, the court accepts the guilty plea. The court also notes for the record that Ms. Bailey was charged with an eligible criminal offense as defined by Revised Code 2951.041 subsection B. Considering the conditions set forth in that code section, factors 1 through 9, the court finds that the conditions are met and will grant the motion for intervention in lieu of conviction. Any objection by the state? No. All right. So I'm accepting the plea, but I am not making a finding of guilt at this time. I am going to hold that in abeyance I will tell you that any conviction of a new offense after today would result in you being convicted of this offense, because we will terminate the intervention plan, and then you would be convicted of this offense as well. But right now, you don't stand convicted of this offense, do you understand? All right. I'm going to stay in these proceedings. I'm going to issue an entry granting the motion and ordering Ms. Dion Bailey into intervention in lieu of conviction under the supervision of the probation department, subject to the following terms. Number one, the intervention plan will be for 1 year. So December 4th or 5th of next year, 2023, I expect that you will be successful and you will terminate the plan and dismiss the charge. But you also have to refrain from the use of illegal drugs and illegal alcohol. You must participate in treatment and recovery support services. You can do that on an outpatient basis. And the probation officer will assist you in that regard. You will submit to regular random drug and alcohol testing, and there's no restitution to pay. And in the next year, I want you to complete 5 hours of community service. And you can do that at your choice of location. So if you want to do it somewhere in your community, if you want to do it at your church, wherever. I don't care where you do it, but I want you to do 5 hours of community service between now and next year. All right, as a condition. All right. Anything else, council?
Nothing further.
State? No. All right, Ms. Bailey, I wish you well, and you are to report to probation so that they can get your plan all in place and those other conditions. Ma'am, do you have any questions? No. All right, well, I will see you this time next year, and hopefully we'll be discussing your case. All right? Just set it for this time next year for you. Oh, got it. Thank you. All right, Ms. Mullen, will you be covering this, or does Mr. Tinker come back? Yeah. Okay, this is the matter of state of Ohio versus DeAndre Glenn. We're back on the record of matters of DeAndre Glenn. Mr. Glenn is now present in the courtroom, and I know that his attorney has had an opportunity to speak with him. Mr. Fox, is there anything you want to put on the record?
Your Honor, I spoke to Mr. Glenn and informed him of the circumstances of the other community trial and the things we discussed in the sidebar. He understands the reason that the court is granting the state's request to set this over. We're prepared to go forward. We have informed him of that as well. And it's not a long delay. It's about a month out, so January 9th. And so he understands that.
All
Is
right.
that correct, Mr. Glenn?
See,
All right, so, Mr. Glenn, no one really wants to continue this matter. I really want to get your case resolved as soon as possible. But due to unforeseen circumstances, which the court considers to be pretty significant, and I know Mr. Fox has explained to you, we need to continue this, all right? And so I am making this the first available date on the docket in January, and that is January 9th, okay? And so I don't think you're gonna call juries in until January 9th. January 2nd is the day after the first of the year, and I think the jury commissioner even brings juries in that day, so you couldn't do it then. the first available date is January 9th. That is when your case is set. I do not expect any more continuances. All right? And so, is there any questions you have for it? All right, now, your attorney indicated that you'd be willing to waive time. You have in the past, and you've executed a speedy trial waiver. Do you waive your speedy trial rights between now and January 9th? All right. Well, if there's nothing else, anything from the state? No. All right, thank you very much. We've got 2 minutes. Yes. Thank you, Mr. Fox. Let's make that, let's make that.
Witnesses are all about the cases. Okay. And then, at some point, I will have to go to Judge Ozark permit, and that's kind of, that's the, at some point, I might have to pop out, but I don't know what's going on. There's any first.
Okay, so, yeah, go ahead and take care of those witnesses. I'm getting ready for Ms. Miller to come here.
Okay, that's fine.
So we'll just.
I'll talk to the witnesses and then.
Okay.
That's fine.
Thank you. Mr. Brett Baker, I did not even know that I had your case as number 5, but you are now up.
I am up.
Yes. I had 7 cases set today, you were number 5. Even number 6 has resolved, so you're up. Yeah, I don't know what this, let's do yet, but I'll go to the prosecutor's side. And then this, now that we discussed issues coming back. She would do it. I know she would. She should be ready.
Yeah, I don't know. It's a back.
He's in Baptist Springs and he's getting ready to go to big inpatient treatment. It's called Pays for alcohol. Pays for alcohol.
What's that? Sure. Absolutely.
Do you want to like? I need to talk to you. Do you want to stay here just for nobody to figure out? I mean, try to push it across the right. You'll have this answer for our motion that you're basically actually the judge has to make a motion. Really, you're just here to relay that I'm looking at it and I will.
We're looking to get the hardy board for our house, it's expensive. I got tons of pepper. I live in the woods. We want to. My whole house, not mine, I'm making it set.
Well, my daughter plays tennis with the straight face.
So that's it. How many people? Well, I thought you were saying something.
money to people who benefits.
Is it waiting on this, Molly? Yes, okay.
I still have a stand here, Judge, but it's so hopeful anyway. Just other than saying she'll be back as soon as she can.
Okay.
But I'm standing in her other room, and I was just as helpful as I was.
Well, you might be helpful in this Mallory's case, it's just a sentencing.
Okay, you say so.
Stand over it.
I can do the first part.
No, forget it. It's a River City violation.
Oh, maybe she has that.
I need this, please, or, so I got. I don't want to say for a few years.
No, we sit in Jody's cases. No. So we would probably come in.
Judge, we need a motion, Mr. Junior, I first.
Yes. Is it on the case?
I'm just allowing.
Okay, just a second.
He's up to the letter.
Okay, yes, sir. All right.
Yes, Mr. Lowry, it's a case that's set earlier for trial, today for trial. I just received this letter last week. Indicated to you last week and this morning. The prosecuting witness was not here today. We heard from Seth Senator about they weren't sure whether she's supposed to serve. My client is on his son this week. He wants to see if he can get a dash time sooner than the federal trial, jury trial. I didn't know what the schedule is like.
Yeah, I can see if we do that, but he'll still need to do a speedy trial waiver.
Okay, well, that's what we do with that, that's what we want to do. He wants a sooner date, he was to answer that. Do you want me to bring him down, you can talk to him on the record, when we go upstairs and talk with him? If I go upstairs, I'll need a bench trial date and a waiver to do.
Yeah. Ms. Howard? Yes. On Lowry, he's requesting a bench trial date and not the beginning of February. And I don't know if we can get it a bench trial earlier than that, February 13th.
I mean, he has a holder, so when is his holder?
Yeah, sure.
When's his holder?
I don't know what he was.
So that's the issue, before we start moving around stuff,
Right.
why don't we see how long his holder is, because if he's being held until March, then it doesn't matter, it's 6 in one hand, half dozen in the other, right?
My understanding is that.
Well, it's 1 for 1 anyway. I mean, it'd be like, well, it's, I'm not even, if you go 20, 20.
I mean, my understanding, I haven't talked to anyone from probation. Well, his holder is based on the conduct in this case. So I guess he's thinking if this case goes away, he's figuring the person's at the show. If this case goes away,
Yeah.
well, I'm looking for a way to, I know they can't that way for conduct, it's not a conviction.
But is that the reason for the holder?
That's what he tells me. I haven't confirmed him.
Okay, why don't we just leave everything the way it is until, can we get some more information about that?
I can try.
Yeah, if we can get some more information about that, I'll work with you on the date and bench, but, if he's being held, just to see what that is for us.
Okay. So, but I can't get you a speedy trial date.
Okay.
Is that not for Sunday? Unless I can do it. You want to give me a couple of days to investigate that? As far as the
Well, I'm making study, be perfect, I know anything saying, I mean. He's not talking to your client, you have, there's a holder, you didn't know the time, what if you literally wouldn't.
I
Yeah, 1 for 1 until.
Right.
trial.
I get it.
But so he stated that he 2 days in the trial. I just don't know. He wants a bench trial tomorrow. But I'm just saying.
Hello?
I don't see the point, he doesn't achieve our feet to fire.
Yeah.
I get it. He just doesn't want to sign.
Well, it's no way to take time. You don't have room out there, and that's fine. Well, you know, I'm used to that, I'm like, oh, that's good. And whatever discovery you're gonna get there.
Well, why don't you maybe give a few days to explore that, and then we'll review
I mean, I can tell, of course, there was a holder that shows up on the website, sheriff's website.
Yeah, but if, I don't know if that's a holder because he, I don't know. None of us know yet.
Okay,
So,
let's get from that day to the next day, stated that it's being trial. 2 days. 14 days. You see the number of the time. I don't know. What? I don't want the 14 days of charge of state.
yeah, so.
Well, I'll wait on that record.
Yeah.
He just doesn't want to sign.
Oh, that's fine. But he's waived all the other times, so we have plenty of time
So I'll work with you all
to see what that's about.
I'll report back to you guys. I'll see what we can do.
Okay, sounds good.
Thank you. All right, this is a matter of state of Ohio versus Richard Miller, case number B 2200624. Ms. Miller is present in the courtroom with her attorney, Ms. Anna Mallory, and Mr. Mark Tierney is standing in for Ms. Caitlin Mullin on behalf of the state of Ohio. This matter is continued today. The court ordered a River City evaluation. I have received a letter dated November 21st, 2022 from Scott McVeigh, the Executive Director of the Hamilton County River City Correctional Center Program. And in it is my understanding from this letter that Ms. Miller is an appropriate candidate for the River City program. And so, will be, and can be accepted. And so we are now ready, at this time, to proceed with the probation violation sentencing. Ms. Mallory, are you ready to proceed?
We are, Your Honor. I think we've given all the mitigation that we intend to give. However, we have the court very aware that she'd like to see her get treatment. I told Ms. Miller she was accepted, you told her she was accepted, so she's ready to.
All right, and I think your mom's, that's your mom, yeah. All right, and so is there anything you want to say, ma'am, before?
No.
Okay. All right. Well, I will, I think this, River City program will be very, very beneficial for you, ma'am. And so I'm gonna go ahead and restore your community control with this special condition that you enter and successfully complete the River City program and aftercare. And I'm gonna add a year to your term, just so you can get through the program, that's all.
Understandable.
That just means that when you first were put on, and I thank you for asking that question, when you were first put on probation, I gave you 1 year of community control. So that was back in August. So, literally from now, from August of last year to August of 2022 to August 2023 would have been your term of community control. But I think that with the River City program and aftercare, you may need a little bit more time than just to August. Not to say you're gonna be in River City past August, I'm just saying just to complete everything. So I'm gonna just add a year to your term, so you can complete everything. But once you complete everything, I'm happy to consider terminating you early from community control. All right, costs remit, fines remit. But if you violate next time, I will send you to prison for 12 months. All right? Anything from the state?
No, Your Honor, thank you.
All right, anything else? All right, ma'am, any questions for me? All right, I wish you well. You have right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you with no cost to you. You understand? All right, I wish you well, ma'am. Sorry. That's okay.
Oh, no.
I had that surgery last week, and he said he can work on Friday. It's
It takes a minute, yeah.
And I feel pretty good today. I already had plans to be gone. Didn't turkey, picking up boxes of evidence and picking up. But I got plans still.
And then your energy balloons, right?
You know, something you use energy, just pain is like a hurricane.
Still, the body is very
That's it. And I had,
yeah.
my nurse was my 23-year-old daughter for 24 hours. She said, hey, you love this, she goes on this movie. And I was out, but I was like, oh, thank you, just anything that's good. She goes, I was Amy Schumer movie, you know, and
You're laughing.
I'm laughing.
Right, that's not
She
true.
left the remote control where the TV is. I called 4 times to she finally.
You cannot watch it as a show. Yeah, she is just funny.
I mean, it was, trying to help. She felt so bad. So, it's,
It is.
but, you know, a couple of days. what's around here? The doctor's like, yeah, I know you haven't known in a long time. And he's like, so I said, no, I'm not going to the those doctors. Like, they get it. Just like Sarah was saying, like, in this business, you don't like to, you can say whatever you want. You better take the anti-inflammatory, you don't have to take the pain. You pay the bills, you're not getting problems. Well, first, you're already taking yeah. That's probably true.
Ms. Zanot, what was under yours?
I'm just waiting for the system process to wrap it up. I think we've got a plea offer, but I do want to disclose my daughter tested positive for COVID. I'm sorry, I can't hear you. I did want to disclose my 14-year-old tested positive this morning, but I tested negative. And we're looking for a plea, it sounds like. And I'm waiting for the assistant prosecutor to come back. Okay.
Mr. Chairman, I know Ms. Leo was waiting on Ms. Molly, Ms. Mullins, another room.
Yeah.
Oh, there she is, never mind, I was gonna ask you, kind of figure out this.
I heard they got to take my leave. I don't know why I took the meetings.
Ms. Mullins, what are we doing?
You're still, I think we've got a, cleaning of copy right now to set it for a different day so I can get restitution. And I know that, I don't know if Mr. Stoll is here because he's in treatment. Oh, yeah, please. All right.
Yes. So you haven't worked out something?
Yes, we have worked out something.
Okay. And so you're gonna do plea today and then restitution, you're gonna figure that out later?
Well, that's why I did not have you on. I do think you could, if you wanted to do the plea today or just come back next week and we'll get restitution, you could bring it in at that time and get that with the done at the same time. I candidly, I do think it will.
Well,
I'll do whatever for once in office.
well, I think an officer's been here. Is there an officer here?
I believe, yeah, there's officers here and everything.
Yeah. So I don't want to bring people back.
Okay.
But whatever, I don't think we do what you need to do, but.
I'm just saying we could offer the plea the day, but I mean restitution, if they were time, so they don't want the restitution there.
Here, this is a situation, it's going to come out of the victim's pocket, but she has not gotten the, appropriate people to get it done at her.
So she has to continue for sentencing.
That's all.
Or does the restitution amount have to be a part of the
No.
offense level?
If they're gonna be paid through probation, we can just go ahead and do the pocket, my client just signed it right now.
All right. And then the last one is,
Ms. Mullins. Ms. Mullins.
Yes.
Mr. Ray. It's like we're the boots for a second.
I'm actually, right after.
Yeah.
So, no, well, actually, I think I need to go to Mrs. Scott.
Okay.
They were, I just don't know, I honestly can't remember because I looked at your case.
Yeah.
It was down with that. That was, he didn't get it.
Okay, let me do this.
I can look at my phone on the website to just double check. I'm thinking that.
Okay,
I think it was like this.
Okay, okay, great, that was it. Thank you. I lost it. Yeah.
We can do it, January 18th.
Are you all talking with Lamasi?
Yes.
Okay.
Sorry.
There's no that, but that's.
See what I report on that. See.
I'm sure the cases that probably going to go forward, I just go. She would obviously. She looks at it, it's not, she lost it.
You need to go down?
If you get brought down, I can mark it there, that's fine.
I'm ready to go.
That's probably easy.
Yeah, it's probably easier, because by the time you get up to there,
Right, it's here for us now. do what we have to do. It's a great process. Yes.
Well, so that, so what happens, growth farms, all that, this is plan goes, then they also just act. Try to play this side, that's why we found this side. Oxygen grows, seed search. Part of the partial.
Yeah. Yes. Yes, that's everyone. That was not the decision. So this is just literally, yeah. It's under. So it's 29.11.212.
Maybe with it. Yep.
Ms. Miller?
Yes, ma'am.
Oh, here she is, okay. Mr. Baker, what is on the group case?
No, I'm waiting for the prosecutor to come back. I was just providing some last minute body cam discovery. I'm going to discuss that with my client when he's brought down, and then I think we'll be in a position to let the court know at that point.
Okay.
The prosecutor said he's willing to reach that someone else will come over.
Okay. All right, hopefully we'll get some cover this plea.
Is there a victim? Is there a victim? Are you looking to victim impact?
Yes. No, it's not this.
That's okay.
That's right.
Are you gonna cover?
Just briefly, yes, Your Honor.
Okay.
Ms. Muller takes care of her other affairs.
Okay, thank you. So, I have a plea. And did Ms. Smallwood sign this already? Yes, Ms. Smallwood already signed.
Yes, ma'am.
Okay, thank you.
All right, this is the matter of State of Ohio versus Zachary Stillwell, case number B 22-03428. Mr. Stillwell is present in the courtroom with his attorney, Ms. Jody Note, and Ms. Caitlin Drew is present for the State of Ohio in Ms. Smallwood's place. All right, so this matter is set for a jury trial, and I will hand the plea documents. Is this how your client wishes to proceed today?
It is, Your Honor.
All right, Mr. Stillwell, is that accurate? All right. Sir, are you the Zachary Stillwell named in this indictment?
Yes,
How old are you?
I'll be, 51.
You 51 now?
Yes,
Okay. How far did you go in school, Mr. Stillwell?
Tenth grade.
All right, did you ever obtain your GED?
I work for another class at work at school.
All right. Are you able to read and write English language well?
Not well, but I guess read it. I'm not very well.
All right. Were you able to go over these plea forms and your attorney read them to you?
Yes, ma'am, she did.
All right. And did you understand after what she read?
Yes, ma'am, I did.
All right. Are you a U.S. citizen?
Yes, ma'am, I am.
Have you ever served in the military?
No, ma'am, I did not.
All right. I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom there are signatures. I recognize this is no signature here. Is this your signature here, sir?
Yes, ma'am, it is.
This is an acknowledgement by you that you understand you have a constitutional right to have a trial, which is set for today. But when you sign this form, you're indicating to the court, I understand that, but I don't want a trial. I'm waiving my right to a trial. Is that your understanding of what you would do when you sign this form?
Yes, ma'am, it was.
Do you have any questions about this form?
No, ma'am, I did not.
Did you sign this form after consulting with Ms. Benoit about your constitutional right to a trial?
I believe, yes, ma'am.
All right. Do you have any questions about your constitutional right to a trial?
No, I did not.
I also have in my hand a 3-page document entitled Entering Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page, there are signatures. I recognize the prosecutor's signature here, Ms. Benoit's signature here, but up here, sir, where it says signature dependent, is that your signature?
Yes, ma'am, it is.
All right. And I will note for the record that this was signed by Ms. Mullet and her bar number is there. Yes, ma'am. All right. So it's my understanding that this is going to be a plea to a reduced charge of burglary, a felony in the 4th degree. Is that accurate, Ms. Benoit?
Yes, it is.
All right, is that your understanding as well, Ms. Burke?
Yes, ma'am.
All right. Sir, are you under the influence of any medications, alcohol, or drugs today?
Medications that I can take for schizophrenia disease.
Or,
Schizophrenia.
all right. Does that medication, while it helps manage your diagnosis, does it interfere with your thinking in any way?
No, it's not.
All right, and are we able to have good communications with your attorney and understand what you're doing here today?
Yes, ma'am, it was.
Do you now, or have you ever, well, you said you're managing a diagnosis of schizophrenia. Is there any other mental health diagnosis or difficulties you've had?
No.
All right. Are you presently under any type of probation or community control supervision in this or any other state?
No, ma'am, I was in the other state now.
All right. Has anyone forced, threatened, or coerced you in any manner into entering into this plea of guilty today?
No.
Has anyone promised you anything at all if you enter into this plea of guilty today?
No.
Are you making this plea of your own free will?
Yes, ma'am, I am.
All right. Now, it's my understanding that you were charged with 1 count burglary, a felony in the 2nd degree. The state is asking to amend it and reduce it to, or just reduce it to a felony of the 4th degree. It's still burglary. Is that what you talked with Ms. Benoit about for this hearing today?
Yes, I did.
Did you have an opportunity to go over this 3-page plea form with Ms. Benoit?
Yes, ma'am, I have.
Did she answer all your questions about it?
Yes, ma'am, she did.
Do you understand it?
Yes, ma'am, I
Do
did.
you understand what it says?
Yes, I did.
All right. Do you have any questions about it?
No, ma'am, I did not.
Mr. Stillwell, do you believe you had enough time to sufficiently talk with Ms. Benoit about your case before this hearing today?
Yes, ma'am, I have.
Has your lawyer answered all of your questions to your satisfaction?
Yes, ma'am, she has.
Have you had an opportunity to either review and or discuss the evidence that the state has against you with Ms. Benoit?
Yes, ma'am, I have.
Madam Prosecutor, to your knowledge, will you put on the record whether or not the state has provided discovery, including any Brady material evidence, if any, to your knowledge?
Your Honor, to my knowledge, we have complied with the rules of discovery, and we believe by pleading guilty is within these facts.
All right. Ms. Benoit, do you acknowledge what you're saying?
I agree, Ms. Burley.
Thank you. Mr. Stillwell, are you satisfied with your attorney?
Yes, ma'am, yes.
All right. Sir, do you understand the charge of burglary, a felony of the fourth degree against you? Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in the reduced charge of burglary, a felony of the fourth degree? You understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately. This being a felony of the fourth degree, you understand that you are facing up to 18 months in prison and up to a maximum fine of $5,000. You understand that by sentencing you to prison, upon your release from prison, you could be on post-release control for up to 2 years. And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Are you on post-release control right now? Well, if you are on post-release control and you committed a felony offense while on post-release control, do you understand that upon being convicted for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains on your post-release control time or whichever is greater? All right. Since this is a felony of the fourth degree, community control is a possibility. Do you understand? Do you understand that I could place you on community control for up to 5 years instead of sending you to prison? Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court? And if I place you on community control and you violate the conditions of community control, you'll be brought back before me for a more restrictive sanction, which could include the imposition of a whole host of things, but the imposition of prison time up to 18 months as the most severe penalty. Also, if I impose court costs and you fail to pay court costs, I could order you to do community service. Do you understand?
I do.
Mr. Stillwell, at this time, do you have any questions whatsoever?
No, not today, ma'am. Thank you.
When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand
Yes, ma'am, I do.
that you have a right to a trial, which is set for today, either to the court or to a jury of 12 persons?
What is that, ma'am?
Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes, I understand that too.
Do you understand that you have a right to have witnesses subpoenaed to come to court and testify for you?
I understand that too, yes.
Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes, ma'am, I do.
And finally, do you understand that you cannot be forced to testify against yourself at trial?
Yes, ma'am, I understand that.
Do you understand each of these rights that I explained them?
Yes, I have.
Do you have any questions whatsoever?
Yes, ma'am, I don't.
All right. You understand that if you plead guilty, you are waiving all of these important constitutional rights?
Yes.
Knowing everything the court has discussed with you today, Mr. Stillwell, do you still wish to enter a guilty plea to a reduced charge of burglary, a felony of the fourth degree?
Yes, ma'am, I am.
All right. Counsel, is there anything further before I accept the plea?
No, Your Honor.
All right. May I hear a statement of facts?
Yes, Your Honor. Zachary Stillwell, on or about the 24th day of June in 2022, Hamilton County, State of Ohio, by force, stealth, or deception, trespass in a permanent or temporary habitation of any person when any other person than the accomplice of the offender is present or likely to be present, Your Honor, contrary in violation of the law.
All right. Mr. Stillwell, did you hear what the prosecutor said you did?
Yes, ma'am, I did hear it, yes, ma'am.
Is it true?
No, yes, it is.
All right. What is your plea to count 1, burglary, as reduced to a felony of the fourth degree? Let the record reflect that Mr. Zachary Stillwell was present in court with his attorney, Ms. Jody Gannott, and that Mr. Stillwell was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Stillwell understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Zachary Stillwell guilty as to count 1, burglary, as reduced to a felony of the 4th degree in violation of revised code 2911.12 subsection B. Counsel, is there any reason why sentence should not be entered today?
Your Honor, we would ask for PSI, as I understand the state would like to investigate the exact amount for restitution purposes.
All right, and so I will not only order a pre-sentence investigation report, but I'll order a victim impact statement. And we will continue this matter for sentencing. Ms. Howard, can you give us a date?
January 18th.
I will be in room A, but I can come in after that, 10 o'clock.
Let's do another time.
Can we do the 19th?
That's fine.
All right, January 19th, 9 a.m. Mr. Silva, you will have to report to the probation department today for pre-sentence investigation. It's just a quick interview. I'm gonna ask you to cooperate fully with their investigation and answer all questions truthfully. If you fail to do so, you fail to go to probation, you fail to answer truthfully, it will affect sentencing. Do you understand? All right,
I'll walk you down, Your Honor.
all right, thank you very much, and we'll see you back here on January 19th at 9 a.m. Thank you. Mr.
Yes, Your Honor.
Okay, great. Yes, it does. Did you need to wait till this, Motley fix that?
I think I do need to talk to her, Your Honor.
All right.
I think that I need to go on the stage.
Okay. Thank you too. Hope you're in order with the-
She's a yes, December 6th. Oh, okay.
Yes, 12/6.
She gets it.
She said that.
What's your jury commission? Will you go here?
I don't know.
Says yes, 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 everything else, so, okay, we'll just wait a few more minutes to stop. Yes. It's not only a state test.
Yes. Oh, yes.
Prosecutor and stuff.
Not a problem.
Okay.
The gender just being party.
Oh, sorry, thank you, I appreciate you checking.
Hey, Steve.